Are you Jalen Hendricks?
Yes, ma'am. Good morning.
And Mr. Hendricks, you were previously here in cause numbers 23 DCCR 2323 and 25 DCCR 0574. Entered pleas of guilty in each of those cases to evading arrest or detention with a motor vehicle. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
The state has, Judge.
Are there any additions or corrections?
Not from the defense.
Not from the state, Judge.
Mr. Hendricks, do you have a driver's license?
No,
Okay, so I'll explain what I'm going to do in a second. So I'm going to find Mr. Hendricks in each of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 23, DCCR 2323, I'm going to follow the agreement you made and sentence you in accordance with it to a term of 10 years in prison, but probate that. You'll be on probation for 10 years. You're ordered to pay a $500 fine and to serve 30 days in the county jail. You will get credit for that time since you've entered your plea. In cause number 25, DCCR 0574, also find that you entered your plea freely and voluntarily, find sufficient evidence to find you guilty, and at this time follow the agreement and find you guilty of evading arrest or detention with a motor vehicle. Sentence you in accordance with that agreement to a term of 10 years in prison, but probate that. You'll be on probation for 10 years. You're also ordered to pay a $500 fine to serve the 30 days in jail that you will get credit for, and follow all of the rules and conditions of probation. So the rules and conditions of probation are very important, because if you don't follow all of those rules, you're going to be right back in here looking at 10-year sentences. Do you understand? You've already agreed to 10 years. So part of your probation is going to be to get you the help that you need for whatever's going on. So you will be assessed for any type of mental health care, and you're ordered by me to follow any recommended treatment. That means medication, counseling, whatever it is. If they say you need it, I'm ordering you to do it. You understand? Also, you are not to drive any vehicle, period, ever, unless you have a driver's license. So you cannot drive. And then and all the other regular conditions of probation, and the probation officer will go over that with you. If you do everything that you're supposed to on this probation, it's a great opportunity, because you'll be able to serve that 10-year sentence while you're on probation instead of in prison. But again, if you violate any of the conditions of probation, you will be right back in here and you'll be looking at that 10-year sentence in each of those cases. You understand? I'm handing you in each of your cases the trial court certifications. It shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. Good morning. You're Lamone Yeoman Jr.
Good morning.
And Mr. Yeoman was previously in court on probation for aggravated assault with a deadly weapon, and also burglary of a building, and pled true to allegations in the motion to revoke those probations to counts 1, 2, 4, and 5. Does the state have any evidence with regard to the others, or are you ready to go forward?
No, Your Honor. Just ready to go forward.
And I've received and reviewed the updated pre-sentence report. Has everyone had an
I
opportunity?
misspoke, Judge, on the because I believe you pled true, not true to number 7, which is failing to report. I do want to address those.
Okay.
I'm sorry. I meant that on number 6, the new firearm case, nothing's been brought over, nothing's been filed, so I have no evidence presented on that count.
Okay. Let me get that pulled up. You may proceed.
Would you please?
I'm sorry. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
It's Ms. Cole, right?
Yes.
And how long have you worked for probation?
A year.
And during your time of probation, have you supervised Lamone Yeoman Jr.?
Yes, sir.
And was he required to regularly report?
Yes, sir.
Were there times where he failed to regularly report?
He reported one time on April 7th, and we didn't see him again.
He reported on the 7th. You've not seen him since.
Until he was arrested, yes, sir.
So is it safe to say that on April 11th of 2025, April 21st of 2025, April 30th, 2025, May 9th, 2025, June 6th, 2025, and July 7th, 2025, he did not report as required to see you or to the probation office.
That is correct.
Thank you. I'll pass witness.
Any questions?
I'm sorry, can you give me that date that he did report again?
April 7th.
April 7th. And have you were able to talk to him about the different reasons why he didn't report?
I called him actually on his birthday, and I told him we have a warrant, and he told me because it was his birthday, he was not coming to tell me.
Are you aware of any time while he's, since his removal from safety, are you aware of any times where you may have called him or sent him text messages about a data report that he didn't get those messages?
I called, I sent letters, and I called his mother.
Okay.
And his mother told me that he was aware of the warrant.
I'll pass the witness.
Another question for purposes of proving up count number 7, Your Honor.
Okay. Based, any witnesses or information about count number 7?
Oh, yeah.
All right, then, based on that testimony, I am going to find sufficient evidence to find count 7 true. All right, and so, again, I've got the updated pre-sentence report, as well as there was a letter provided this morning. Mr. Nichols, have you had an opportunity to review the letter? It's
I did
from,
not show it to Mr. Marcus.
and take a look at that. Have y'all both had an opportunity to review the pre-sentence report update?
We have, Your Honor.
Yes, Your Honor, I have.
Any additions or corrections to that report?
Just a correction to the page 1, the bottom paragraph. It says that Mr. Yeoman was absconded from the aftercare program. He tells me he did not abscond. He was kicked out of that program.
Okay. I guess being kicked out's better than being absconded. Anyway, all right. Anything else?
That's what the PSI noted.
And it looks like there was cap of 8 years agreed in the aggravated assault case, and then just really open in that burglary of a building on the state jail to run concurrently, correct?
Yes, Your Honor.
Mr. Rojas, you may make argument.
Thank you, Judge. The court knows from reading the PSI, Mr. Yeoman was in SAFE-P. He did successfully finish the first part of SAFE-P. The aftercare program is a part that he was kicked out of. He pled not true to count 1 as far as, I believe that counts as he was selling K2. What Mr. Yeoman tells me is that one of his roommates in the aftercare was selling K2. All the roommates in that particular room were kicked out because the person selling did not claim ownership of the K2, so everybody in that room was kicked out. And that really just started the downfall for him on the probation judge, because at that point he was released from safety in Houston. He had to find transportation back to Port Arthur. He tells me the phone that he had, the phone number that the probation department had originally, he did not have that phone anymore. So when the messages were given to him to report, he wasn't able to because he didn't know about those. When he finally did get back to Port Arthur, he had trouble finding transportation. And that's when the new offenses came up in August, and as far as the possession and the weapon charge. So according to, if his story is to be believed, that he was not selling K2 and everybody in the room got kicked out.
There's not much for you to argue here today,
I
is there?
don't
You
wanna
haven't
say
given
that
your
it's
attorney anything to argue for you.
Judge, I don't want to say that it's not his fault, but really, if he truly was not selling the K2, he would still have been able to finish that SAFE-P program. And that's what he's asking to give the opportunity to do this morning, is finish that aftercare program, possibly even due to those new offenses, one of them being weapon, maybe even consider sending him to ISF cognitive to help him make better decisions. And if you had more questions about what happened at SAFE-P, Mr. Yeoman is willing to talk about those.
So there was an ISF, okay, there have been 7 administrative hearings. 7. There have been, on the first case, the aggravated assault case, this is the 3rd motion to revoke probation. The first motion was filed literally, it what appears to be a week or two after got on probation, given another opportunity. Then, did he go to ISF? I can't tell. Anyway, regardless. Then we get a new case of while you're on probation for aggravated assault with a deadly weapon. You obviously aren't doing what you're supposed to. You get some jail sanction where you spend 5 weekends in jail. Then you decide to go commit another felony of burglary of a building. You come back in here. We all agree somehow for you to stay on probation for the first felony, give you another probation for the second. And then we're here again. I sent you to SAFE-P. And not only did you get kicked out of SAFE-P, whether it was your fault or not, you also have been arrested now for 3 new offenses. Is that right? 3? 2. 2. Sorry, 2 new offenses. Mr. Nichols?
Judge, I'd urge the full extent of the cap that was agreed upon. Even without the problems in safety, the fact that he simply has not participated in his probation for the last several months or most of the last year, that he's been given multiple chances. And if you go back to his original PSI from 2019, from the 2019 offense, the ag assault, he downplays what he did. And he's never taken responsibility really for what he does. And I think the recommendations of the probation are correct in that he just refuses to grow up, refuses to take responsibility for his actions. So I think the 8 years is appropriate, Your Honor.
I think you're lucky that Mr. Rojas got you a cap of 8 years, honestly. Because what you're on probation for is a second-degree felony, the first one. And the opportunity after opportunity after opportunity that I've given you and probation have given you, at some point we kind of start taking it personal that you're just saying, screw y'all, I don't have to do anything. She's going to keep giving me probation. I'm going to come in, I'm going to write a nice note, take responsibility at the last minute. You've done none of that. You've done nothing that you're supposed to. You make me look like an idiot up here for giving you all of those chances. I'm going to find in cause number 19-32846 that you entered your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily. Find those counts true. Also find count 7 true. Find sufficient evidence to find you guilty, and at this time find you guilty of, which one is that? Aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 23, DCCR 1556, also find counts 1, 2, 4, 5, that you entered those pleas of true freely and voluntarily. Find those counts true. Find count 7 true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a building. Sentence you in accordance with your that agreement to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In each of these cases, they'll run concurrently, which means together at the same time. I'm handing you the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of those judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. You can go back with the paper.
Thank you, Your Honor.
Thank you. Thank you. This needs to be skipped. Good morning. Are you Adrian Hayward Jr.? And Mr. Parker, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Hayward, in cause number 24 DCCR 2149, you're charged with the third-degree felony offense of assault family violence by impeding breath or circulation from May 23rd of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Hayward is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what
This
is
is his first case that I'm showing, Your Honor. If he's going to be released on bond before sentencing, I'd ask, obviously, that no contact with the victim, he stay away from that address, that he not be allowed to possess a firearm. While the allegation isn't for using a firearm, there's allegation in the reports that he had brandished one that evening.
Okay. What's your relationship with Rihanna McLean?
Cover my girlfriend,
It was your what?
ex-girlfriend.
Your ex-girlfriend's cousin. So there's no reason for you to be around her, or it sounds like your ex-girlfriend at all, or anybody like that, right? So here's what I'm going to do. Based on the nature of your plea agreement, I'm going to reduce your bond in your case to $1,000. Condition of that bond, if you make it, is that you are to have absolutely no contact or no communication in any way. That's obviously in person, but it's through social media or sending messages or anything with her. Do you understand? You can't go to an address where she is. If you're somewhere and she shows up, you have to leave. Do you understand? And then also, as a condition of your bond, you are not allowed to have any firearms at all. So if you own firearms, you need to get rid of them. If you have a family member that can take them, I don't care what you do with them, you can't have them or have them in your home or your car, okay? Any questions? All right, we'll see you back at sentencing.
Thank you, Your Honor.
Thank you. Good morning.
This morning, Your Honor.
Okay.
I'm not opposed. States.
Hold on a second. Good morning, you're Traylon Hill? I don't see, what is it?
It's a motion for continuance. By Mr. Matuska, Your Honor.
You just paid the bond before.
Nobody's talking to you right now, okay? Don't say, Mr. Hill, don't say a word unless someone asks you a question, okay? I don't see the motion, is what I'm looking for. It may be one of the,
Cases that order.
all four. I just got a script error. Do I hit yes or no?
Yes, it's fine.
Sorry, now my computer's acting up.
Did you try to run it? John, did you try to run it?
Huh? I haven't seen it yet. It's not even showing up, but now I've gotten to where I can't X out of anything, so. All right, so Mr. Hill's cases are set for trial to begin with jury selection next week. And Mr. Matuska, you filed a motion for continuance.
I did, Your Honor. At the last setting, Your Honor, the court informed me that this case was urgent. We did receive all the discovery. I printed out all of the written reports and provided a notebook to the jail. I've gone down there with the laptop. The guards at the jail have informed me that Mr. Hill is refusing to come out and meet with me, to go over his discovery with me.
Okay.
And I have not had an opportunity to show him based
Don't
on.
talk, I'm going to talk to you in a minute.
I'm just saying.
Don't talk over
I'm
people.
not talking over him, let him know.
You're talking over me right
I
now,
own
and you're
him.
talking over him.
I own him.
Mr. Matuska,
Based upon that information I'm receiving from the guards, I've also reached out to the family, Your Honor. They seem concerned for some other reasons
I haven't been out to the cell in over
that
like
the court may be
5
aware of.
weeks.
But I have made efforts to provide him the opportunity to see his discovery, but the jail is telling me he's refusing to do that.
all right, so I'm going to grant the motion for continuance. I am also going to go ahead and order an evaluation be done. Mr. Hill, it's very important if Mr. Matuska or any doctor or anyone comes out to visit you, that you visit with them. It's going to help move your case along, okay?
Cool.
So it's,
I paid for Burbank, I don't even know who this is.
so
I'm
you,
gonna just do it.
Mr. Burbank has not been paid because he's not here to represent you. Mr. Matuska is your
You
lawyer.
can put up his file
I represent,
on TV.
I appointed Mr. Matuska, who is an excellent attorney, to represent you. Mr. Burbank got off of your case.
But the reason why is
listen.
because I've been to court 14 times, and I'm looking to go because I have no evidence on me.
Listen,
during this whole entire
you and me both are ready
So
for
y'all
you to
invaded
go.
my- y'all invaded
Both
my
of us
community.
are ready. Go back with the bailiff.
Y'all invaded my
Listen, if they
community.
come out to visit
All my
with you, you need to
constitutional
visit with
amendments
them.
y'all
Go
made.
back with the bailiff. All right, are you Colton Armstrong?
Yes, ma'am.
And Mr. Armstrong was previously in court and cause number 25 DCCR 0002, entered a plea of guilty to theft of property enhanced to a third-degree felony. There was an agreement for a 10-year term to be probated for 10 years. There was not going to be a fine and $20,000 in restitution. Is that correct, that was the agreement?
I thought it was, is it 10 over 10?
That's what I had, just 10
Okay,
over
that's
10 with
fine.
the 20,000 in restitution.
Yeah. And then I received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your
I
Honor.
have.
What is the status of the Hardin County case?
Pending.
I have made multiple attempts to contact Mr. Hopper over there to no avail. I'm sorry.
Okay,
I've spoken with him about it. He doesn't, at this stage, isn't offering probation. I think what I would do, once Mr. Armstrong gets granted probation here, he would post a bond on that case and then just set it on the regular trial docket in Judge Thomas's court. And offers tend to change over the course of the pendency of the case. I think Mr. Hopper's going to retire probably before the case will be reached for trial.
Judge, our position.
I'm not
I know.
being flippant. It'll be assigned to someone else.
Our
yeah.
position on this was to make this offer obviously conditioned on the amount of restitution and his paying the restitution. As you can see, he pled to more than one paragraph, which elevated it up to
Sure.
about 10 over 10. And we would, of course, be asking for the full 10 on the revocation.
Right, and y'all also, I guess, understand the recommendation that was made after the substance abuse assessment with regard to ISF cognitive and then JCDI after.
I would let Mr. Armstrong speak to that, Your Honor. I think and in counseling with him, he advises that he thinks he's at a point now where he has a new child, needs to be there for his family to support.
Well, based on the criminal history and the 2 different probations that have already been revoked, if I'm going to go along with the agreement, then I want him to have every tool to be successful. And that's what's going to happen. So it's not necessarily meant to be a punishment, but if that's what's recommended, then they're the professionals, and I want to give you all those tools so that you can be professional, be there for yourself, your kid, and everything else. So then, anything else?
It's cognitive track or something.
Cognitive track, and then JCDI as aftercare. So there, he gets both.
The problem there, Your Honor, is that he does have a pending case in Hardin County, so I don't know that he'll be able to go to that.
Hill's going to have to be, once I'm done, they'll transport him over there because there will be a hold here, and he'll have to get that case taken care of before he goes, one way or the other.
So if he were to post bond, I guess he would still be.
He won't have a bond. He won't be able to get out in this
That's what I'm
case
saying.
because he'll have an ISF hold.
Okay.
So, and if something happens and that case does not get resolved, file something, let me know, and depending on the time frame that he's sitting, I might reconsider, but I want to at least order that, and then we'll go from there.
Since he's getting probation here, that doesn't impact.
Right. If it doesn't impact it and it's going to get set on some docket that doesn't get taken care of for however, long, then just let me know. And then potentially I would hold it in abeyance, the ISF, if he has to go sit over there for a long time. Okay?
Would the court also consider imposing a trespass warning for all TNT record locations and the use of any and all of their services? I know they have multiple locations and businesses here in Henry.
Just stay away from TNT.
All right, so here's what I'm going to do. Mr. Armstrong, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney. Find you guilty of theft of property enhanced to a 3rd degree. Sentence you to a term of 10 years in prison, but probate that. You'll be on probation for 10 years. There will not be a fine. You are ordered to pay $20,000 in restitution and to follow all of the rules and conditions of probation. Sorry. Does anybody else see that? There's a bug flying around. I feel like I look crazy. You're going to be ordered to go to the cognitive track of ISF, and then through the JCDI program as aftercare, which is an outpatient treatment program. So you'll be transported over to Hardin County. If something gets worked out once you get there, then you'll go straight from there to ISF. If for some reason that doesn't get worked out and things are going slow, Mr. Kimler will get in touch with me and we'll reconsider the ISF. I want you to go because I think it's good for you. I want you to start getting your GED. I'm going to order that as a condition of your probation, you are required to, once you're out, and there might even be the opportunity in ISF to start that, I'm not sure. But if not, once you're out, within 30 days of being out, I want you to start that program. Again, that's going to be helpful for you, for your children, to get better jobs, and so that is part of your probation. You are ordered to not be on the premises of or use the services of TNT Record as a condition of your probation also. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. And I don't know.
In this
kinda
intense
reconsider.
courtroom
I was
session,
with the
Judge
Hardin
Raquel
County
West
stuff.
confronts a
I'm gonna
defendant
do
who has
this.
repeatedly
Listen,
violated
hang
the
on.
trust placed
Listen.
in him through
This is what
multiple
I'm gonna do,
chances,
just because I
probation
know that can take
opportunities,
a
and
while over
rehabilitation
there.
programs.
I'm going to hold the ISF.
After failing to report,
I'm gonna
facing
hold
new
ISF
criminal
in
charges,
abeyance.
and ignoring repeated warnings, the court finally decides that accountability must come first. Despite the defense asking for another opportunity, the judge makes it clear that endless chances cannot continue when responsibility is repeatedly avoided. With previous warnings ignored and serious consequences now unavoidable, the defendant receives his sentence, proving that every decision has a consequence and justice will eventually catch up.